So is this live now?
I believe so. Why don't you?
Okay. Well, hello, everyone. This is Joe Potuto. Obviously, I'm not Joel Wallman. He is somewhere, I would say MIA.
Mrs. Adelson, can you hear me?
Yes, I can.
All right. We can hear you clearly in the courtroom as well. Your counsel or counsels are with me in the courtroom as well as the state. Mr. Zellman or Ms. Fulford, whoever would like to go first, or Ms. Dugan.
Your Honor, first thing I want to address, I think it was last week before, Your Honor, issued the order concerning the prior investigator. When we were first before the court in December, we were told that the defense would have the benefit of what already occurred. I certainly understand the conflict issues, but our client is being punished and prejudiced in her ability to defend herself, not based on her actions, but on the actions of her former attorneys. It's our understanding that one of the things that the investigator did was travel down to South Florida, take pictures, identify times of travel. We don't have those materials, and we're asking for an exception to the court's order to get those materials, not his reports that he generated from interviewing individuals.
The raw materials.
Just the photographs and those specific notes. And if you want to do it in process where Your Honor make sure that that's all that's being transmitted to us, fine. But otherwise, our client's going to have to go to the expense of hiring somebody to do that same exact task.
Problem with this, Mr. Zellman, is if in any way the conflict bleeds over, that compromises the trial itself. The whole point of stopping the trial because of the conflict was not to have to do this a second time. Your client did select who she wanted to represent her. There is a conflict issue tied up in that. At this point, untangling all that is ensnared by the conflict presents more issues. Does the state wish to be heard?
I would defer to your ruling since she would be camera judge.
As to whether any raw materials that were obtained by the investigator could be used, I will give this additional consideration. However, any report that he has made that remains subject to the ruling, him assisting with the defense remains subject to the ruling. Other matters that you need to address, go ahead.
Yes, Your Honor. In December, you entered the order setting court proceeding dates and procedures.
Yes.
I've conferred with the state and we have a few requests for changes in those.
Go ahead.
With respect to the discovery deadline, which is now set for Wednesday, April 30th of 2025, we would like the order to be amended, if Your Honor agrees, to say that deadline will remain. The exception would be if the parties agree to depositions outside of that date. We've had some problems with getting some depositions scheduled when everyone is available. We already have one set in May 14th, so we would like just the opportunity to hold depositions past April 30th if everyone is in agreement.
Ms. Dugan.
No objection.
Very well, the deadline will remain in place. As to whether this would affect any motions that would need to be heard, that would occur once the issue presents itself, but you may schedule the deposition if you need to.
Thank you, Judge. We also were requesting that because of the discovery issues, that we extend the pretrial motion filing deadline to May the 9th and to presenting the final witness and exhibit list to May the 13th. And the state had no objection to that either.
Ms. Dugan.
No objection.
Those dates then will be moved as requested by the parties.
Thank you, Judge.
Any other matters the defense needs to raise?
Your Honor, we had previously submitted a proposed order concerning the wealth evidence, and we had addressed it by email with your judicial assistant in the state. And Your Honor indicated that we would address it here this morning. And the purpose of submitting that is so that there is complete clarity on the court's ruling, that there's not an issue. We are not trying to get into a situation where we're having to seek a mistrial.
As to that, I reviewed the original order and also what was proposed. They didn't exactly coincide. Is there something in particular that you believe needs to be clarified based from the original order?
I don't think that there is. I think that there's a difference in opinion as to what the court's order meant.
I reviewed the transcript on that as well, and I believe as it went to the state presenting any evidence of motive, or specifically that Mrs. Adelson was somehow involved with the offer of money relating to the, I believe, relocation of the children, that evidence would be permitted as far as any general evidence concerning her money, such as what her net worth was on a particular date. That was not going to be presented. But again, as it relates to presenting evidence on motive, that would be presented. What is unclear about this?
I think that clears up the potential confusion, Your Honor.
All right, Ms. Dugan, do you need to be heard on this point?
No, sir.
We've already filed 2 additional motions in limine. There are at least 7 more that we are still working on, and we are hoping to get filed in the next few weeks. When we were here last, I had indicated that there was another motion to suppress. I'd hoped to file previously, but given the depositions that are scheduled, I want to wait until after those, in the middle of April, to get that filed, just to solidify some of the testimony. So but that will be filed before the end of April.
Right. As to the motion in limine concerning the use of the book for impeachment, are the parties capable of handling this matter today?
I'm not prepared for that.
We can, I believe that the state's stance is that much of that has already been heard before as well, but we could get with your assistant and set a time for that to be heard.
The book they're talking about is Wendy's.
The matter can be resolved somewhat quickly, I believe, compared to the other motions, but there should be, let me look at the calendar.
This is a status hearing right now where they're going over.
Either a 30-minute or 45-minute motion on that. Even this week, if all parties are capable of handling it. State defense.
Just looking at my calendar, Your Honor, it looks like I'd be available. I could make myself available almost anytime Thursday and anytime Friday.
Ms. Dugan.
That should work. Maybe Thursday afternoon, we could set something. If I could get with Ms. Kappelman and we'll email Lynn this afternoon, would that be okay?
Contact Lynn to see what time on Thursday we can go ahead and address the issue
Yes, sir.
Yes, sir.
of the book.
Yes, sir. And then lastly, on the venue issue, we have the materials from our expert. I was hoping to file it last night, but still finishing putting all of the materials together. We also have spoken with the state about their position on filing those materials under seal. That motion to file under seal and proposed order is already done. I can submit those today when I get back to the office. And then the materials themselves, I'd like to say tonight, but realistically probably tomorrow.
Please file them as soon as you're capable. If there is no dispute from the state concerning whether it's under seal, you may do so.
Ms. Kappelman indicated yesterday that there was no objection from the state, so that portion's already resolved.
Very well. Do the parties need another case management before we get to the more substantive dates and the orders?
The state does not.
Your Honor, at this point, I don't think that we do. If something arises that we cannot work out amongst ourselves and we need to get court intervention, we will certainly contact your judicial assistant.
Well, let me briefly look at the order that was previously set. We're setting all of the dates and deadlines.
So as you can see, the status hearing is running over the judge's schedule for when things need to be submitted, when things need to be done, and they're running through.
It's already preset by order for 5/16 at 9 o'clock. That will be the next date in which the matter will be addressed outside of any other motions. Unless either party has anything further to address, we'll be in recess for this case.
No, sir.
Thank you, Your Honor.
That is the conclusion of the hearing. Have a good afternoon, everyone.
Okay, so that was cool. That was quick. Let me introduce myself real quick because I didn't get a chance to do so at the beginning. I'm Melissa Hamilton, a professor of law and criminal justice at the University of Surrey. Sorry, Joe. I was trying not to speak over the judge and I spoke over you.
That's fine. And that was what I was going to do to get introductions in. And I said, I'm Joe Potuto. I've been on the show before. I'm a professor of law emeritus. I do consulting work. We are standing in for Joel, who is missing in action. I don't remember quite where he is, but he's not here. So we're going to do our best to fill in and run through what happened at the hearing. Let me just say a status hearing is the judge trying to keep everything on schedule. He sets up dates at the outset when all the interviews, in other words, the depositions need to be done, when all the filings need to be done, when the parties have to submit any motions that they want heard, anything related to the start date of the trial. And the status hearings are the judge just checking in to make sure that everybody is still on target for all those dates that he set. And you heard them talk about a number of issues that are still on the table. The defense talked about needing a little more time to get all the depositions in. They said there's going to be another motion to suppress. The motion to suppress is the defense saying there is evidence that we believe the state wants to use, and we think there's a constitutional impediment to the state being able to use it at trial. And a motion in limine allows the defense to make that argument to the judge ahead of the trial, ahead of when the state might be prepared to use the evidence. It's useful to the defense because if they know that the evidence cannot be used by the state, then they don't have to worry about preparing to deal with it. The one big issue that they talked about relates back to Daniel Roshbaum as the defense lawyer for Charlie, and then switching over to be the defense lawyer for Donna. And I'm reasonably sure that the people who are with us right now listening to this hearing, and to Melissa and me, know the background of that. But briefly, the Daniel Roshbaum was disqualified from representing Donna, and that resulted in an 8 or 9 month delay in the scheduling of the trial. Donna had finally selected the 2 lawyers that you heard this morning who are representing her. And they were completely independent of anyone who had worked on, any lawyer who had worked on the case before. Then they asked if they could use the work that the investigator, that the prior attorney, that is Daniel Roshbaum, had hired to do some investigative work on the case. And you heard the lawyer this morning say there were photographs taken. There was a schedule of when events happened that investigator had worked on. Initially, Judge Everett said, no, but if you want to make a case for this, I will interview the investigator privately to see whether I think it's completely severed from the prior representation, because I do not want this trial to result in a mistrial and Donna having to find another set of lawyers and have another trial because the investigator was tainted by being related to the prior defense. At that interview, Judge Everett decided that the investigator's work could not be used, that it was too risky, it was too possibly entangled with the prior defense. This morning, what you heard the lawyer say is, we understand we can't use the reports that the investigator did or any opinions he might have, but can we use the photographs he took, the raw material that he put together, or are we going to have an investigator go back out and do it again? And what you heard Judge Everett say is he does not want to be anywhere within 10 miles of another conflict problem, and he's inclined to say they can't use anything, but he's willing to hear them make the case for the raw materials are okay. We understand nothing else will be admitted. So that's my, quick summary of, I think, the biggest thing that they talked about today, but I'm going to throw it to Melissa for what she heard and what she might want to focus on or add or contradict for that matter.
Oh, don't give me that opportunity. But no, Joe, that was just absolutely a wonderful recap right off the top of your head. And just to be clear for the audience, Joe will be on the webcast this afternoon, later today, and we'll be joined by Stephen Webster. Joe and I will be back as well to talk some more about what's going on in the case. Just a couple of comments I had on what I saw, and then I'm going to take the opportunity now I have her to ask Joe some general questions overall. Judge Everett, again, is showing himself to be methodical, reasonable. He was on time, which is why we didn't even have a chance to properly introduce ourselves, because Judge Everett was starting right on time. He does not waste a minute. So he's just quite impressive overall and continues to be so. And so what you saw here was some of the nuts and bolts of the case, and it may seem to be boring at times, but this is how, the whole picture of a trial and how justice works. Is a lot of times it is tedious stuff, but it is important in the end. And so any of the issues that they have been raising today can have significant consequences in the trial. But overall, then it also matters to justice. So what you are seeing in terms of this whole case, particularly with how Judge Everett is ruling over it, is not necessarily common. A lot of trials have a lot of hiccups. Things don't start on time. Things get prolonged. You get a lot of tempers. But here, Judge Everett is doing a really good job. And one of the reasons I emphasize that is not only to praise Judge Everett, and he does deserve that, but just to indicate that this is not necessarily indicative of how the criminal justice system always works. But the other thing I want to point out is what I did, some of the notes I was taking was the defense counsel in terms of the discussion about how much they're going to be able to, the prosecution can bring in Donna's wealth. You may have noticed there he threw in a dig about seeking a mistrial if the judge did not rule in their favor. So that was kind of, that was a dig that Judge Everett didn't need to hear, but it stood out to me. And then, let's see. So we're going to talk more about the whole case this afternoon. But as I said, Joe, I've got you here, so I might as well pose some questions for you. And I know that some of these questions you have responded to before, but the reason I'll ask again is because as this case progresses, as we all know, things have shifted, things have changed quite dramatically. Defense counsel has been rotated in and out. And so just your thoughts on this may have evolved as well. Well, one of the things, so what you all saw there is Jackie Fulford was there to represent Donna. And as you all know, Jackie is relatively new to the case. But my question here is going to be, Jackie is a former judge in the area. And so, Joe, what do you think? How is it to be a former judge when she was the one that was behind the bench? How do you think it feels for her to be on the opposite side of the bench, where instead of her controlling everything and making the judgments and having people appeal to her, she now has to be on the other side of it again, and she's now asking for Judge Everett, and she is reliant upon whether Judge Everett is granting some of the things she's requesting. What do you think she's feeling?
what may be a little like a law professor being on the other side and responding to questions rather than asking them, which is where I am right now. I don't think she was on the bench for a significant amount of time, so I don't think she got embedded in being a judge as compared to being a prosecutor. And she'd been a prosecutor for many years. I think it's probably a little odd to her. I don't know whether she was on the bench at the same time Judge Everett was, and so might have sat in on, bench lunches with all the other judges or socialized with the other judges. If she did that, it would be a little awkward, I would assume. But I think right now she's put on her prosecutor hat and she's gung-ho to prosecute this case, and any view she has had about what it was like to be a judge is in the rear view mirror. I don't even know that if she thinks he makes a ruling she wouldn't have made, that would be all that different. I know as a trial lawyer, when a judge makes a ruling you think is wrong, you don't have to be a judge to say, I know this one was wrong. Maybe it affects her a little, but I think she's ready to go.
Well, on a related note as well, as you mentioned, she's a former prosecutor. Now she's acting as defense counsel. I wonder how much people who do switch sides there miss all the resources they had as a prosecutor, and all the ability to gather the information, and then also to have the technicians, for example, to review that information. You don't have it nearly often as much resources as a defense counsel. So I wonder whether she's missing some of the access to evidence and the investigation as she had before.
I think she's probably missing the ease with which and the sort of the system that's in place to get things done. You hand it off to someone and they bring it to the forensics person, or they bring it to the person who's going to be dealing with some of the technical information. Whereas on the defense side, and she's working for a client who has enough money to be able to deal with this, they still have to find the people. And they don't have the same network available to them. And so I suppose that bothers her some. Now, some of it was done when Daniel Roshbaum was on the case. Now, they can't use the same people because of the conflict issue. But I think some of it was sort of the routine as to what needs to be done, I think, is certainly in place. Do you agree? How would you do it? Do you think she's feeling a little overwhelmed by having to find the experts and find the tech people and, do it?
Yes, I kind of think that it is very different for her, that she's navigating a different field than what she'd done before. And with this being a really high profile case, she's out there. So I also wanted to ask you, as a law professor, putting your grading hat on a curve, what is your current grade for how Jackie Fulford is doing?
Well, off everything and not simply today, I probably would say a C plus B minus. And it's primarily because I think they've been doing a lot of things that either were needless and might irritate the judge in terms of spending the time. And also in some of the previous motions, they have overstated their case in ways that are just, in my opinion, silly. We were on, STS last week, I think, and the issue then was in the motion that they had filed, saying that it was not a particularly nasty divorce. And, there's a record that's about 5 inches thick of that divorce. And I think those sorts of not necessarily misstating the record, but overstating it as much as they did is not useful in front of the judge. It will not be useful in front of the jury. So that's why I am where I am in terms of the grade.
Thank you for that. I put you on the spot there, so that was probably unfair, but thank you for playing with it. My other question, they mentioned today about the defense is going to file a motion for change of venue. How are you feeling about how successful they might be? Although obviously that suggests that since they want to file it under seal, is that there might be some surprises in there. So you might not know of everything that they might include in it, but just your thoughts?
Well, they did hire an expert who I assume has been doing some interviews and some of the other kinds of statistical analysis about whether you could get an unbiased jury. I have heard, I heard Joel talk about having talked to a number of people at a rest stop or a restaurant when he was in Tallahassee last fall when there was going to be a trial. And of the people he talked to, none of them had even heard about the case. I've heard other people on the air say, they go to a cigar bar and smoke cigars. I think that's Patty's Playhouse, and no one there knows anything about the case. Tallahassee is a university community, which means there's turnover. Professors move, students move. There's much more lateral movement in a university community than in a stable community somewhere else. So I think I'm pretty confident that they're going to be able to sit a jury, and they cannot make that motion until they've tried to sit a jury and said it can't be done. Until then, it's premature to be, positing the possibility that you can't get a jury in Tallahassee. And I think the Florida law is pretty clear that you need to do your best to be able to try it in the home venue. And I feel very strongly about that. That's where the disruption to the fabric of society happened by the crime. And it's that community that seems to me should have the right and the opportunity to, hear the trial.
Yeah, I think you're right on that. Tallahassee sometimes is portrayed as a small town, but you're right. A lot of ways it's not. It is a university town, as you indicated. People come and go. It's also the legislature is there. They come and go as well. And the crime did occur quite a number of years ago as well. And so whatever taint from the actual occurrence of the murder probably has dissolved a bit. Another question until we get kicked off anyway is often Donna is described as the matriarch mastermind of this. Do you think she was really the mastermind? How much do you think it was her strategy versus Charlie's strategy? How much did he have to get her approval? Your thoughts on that?
I think she was the moving force in this. I think Charlie wanted to make mom happy. I don't think that he would have orchestrated the murder because of his sister. I think it was because of his mother that happened. So I think she was maybe the deus ex machina behind the scenes. Whether she was the one who thought up the particular scheme they used, there I'm not so sure, but it was not a very good scheme. And if I were she, I wouldn't take credit for it. So I don't know whether she was actively involved in figuring out how they were going to do it. I am certain that she was kept apprised of what was happening at every stage. I don't think she's the kind of person who would have said to her son, see if you can figure out a way to get my son-in-law killed, and then sort of sat in her house and let it all take place without her active knowledge and finger on the pulse in case she thought, one part of the scheme didn't make any sense.
Yeah. And we know that the deposition of Wendy Adelson occurred earlier this week. Have you heard any secrets about that?
I have heard not a word, and I guess I wouldn't expect to. I'm not in the Tallahassee. I don't go to the courtroom in Tallahassee where you might hear, whisper of something here and there. So I don't know, and I assume you don't know, sitting in England, what might have occurred at the deposition.
I had not, although the deposition did occur in Austin, Texas, where I lived for about 20 years or so, and am a graduate at the University of Texas at Austin. So anyway.
Yeah, that's right. You are right.
I did.
Yeah. If I could add something, because I saw a couple of people in the chat talk about it. The book that the defense lawyers were talking about where they had made a motion that they didn't want any reference of the book coming in was Wendy's book that she had written, which she claimed was fiction, but tracked her life about as closely as the photograph would track someone's face and body. It was that close. And in Charlie's trial, Georgia was able to talk to Wendy on the stand, on direct, about the book. These lawyers have argued that there's nothing about the book that should come in on Donna's trial, and Judge Everett ruled that that was true in terms of anything that Georgia might do in interviewing or questioning Wendy when Wendy is called to the stand as a state's witness, but that the book can be used to impeach Wendy on the stand. If there's ever a trial of Wendy, that book will be relevant and admissible. The question is the extent to which it can be admissible against Donna. And they've been trying to keep it out. And they've been trying to keep it out in large part because it looks like it goes to Donna's motive. You know, the book underscores how miserable Wendy was in Tallahassee and how unhappy she was in the marriage.
Yes, and she, if I recall correctly, she wrote that book, or at least it was published right around the time of the murder. So it would have represented that some of her thoughts at that time rather than retrospectively.
Right.
Yeah. So again, something that you've addressed, but things have shifted in terms of, do you think Donna's going to testify? And one of the things I'm suggesting might have shifted is she's now testified, at least in these pretrial hearings, several times, and she's not been able to convince Judge Everett of various things. So I'm wondering whether she's no longer going to be as confident as she previously had seemed to be that she could convince everybody of everything that she's saying. So do you think she's having second thoughts?
I doubt it. And I think they have to have her testify to explain away her connection to the bump and other things that occurred. I don't know any other way that some of that evidence is going to come in. I don't think the lawyers want to put her on the stand because I don't think she's a very good witness. And you just reminded me of why I said a grade of C- plea plus. In fact, now that I'm reminded of it, I might just say C-. You can't get to B on this because on her flight, right after Charlie's conviction, as we all know, she's in a frenzy to get out of Miami. There's frenzied emails and connections with a travel agent, with others, to get her a visa to go to Vietnam. There are questions about, where can we go where there's no extradition treaty. She wants to talk about getting her affairs in order. She wants Wendy to know where the will is and where the property is. She talks about asking Dan Rashbaum, can they get away? And he said, well, you might. And then they get arrested at the airport. And the reason why you have, in being reminded of that, I'm going to move my grade to just C+, is because her explanation for that, in my view, was sillier than the explanation for the double bump, the double extortion theory that Charlie used. Because her explanation, instead of just saying, we were really afraid we might get arrested, we didn't do anything, but we just didn't think we were going to get a fair shake in Tallahassee. Instead, she says, well, we just decided we needed to take a break. We needed to be able to breathe a little, get away, have some time off. And they wanted to go to a country without extradition because they wanted to come back, under their own will. And they just didn't want to be thrown in a jail somewhere in a third world country where the accommodations wouldn't be very good. And it's just, I thought to myself, so why didn't they, instead of going to try to get to Vietnam, why didn't you go to Bermuda or, somewhere warm and pretty. So I thought that explanation that they let her give on the stand was sillier than the double extortion theory. So I'm moving my grade down. I mean, I just thought that was hilarious as an explanation. I don't. You may be kinder about these things than I, but I couldn't deal with it. So.
Well, you are revealing a secret of us law professors that sometimes we grade things and we go back and regrade, and grades can shift as we think about it.
We do. We try to be careful, right?
Yes. On that note, since I know that you are excellent at recapping, some people in the chat didn't know what the bump meant. So can you quickly give a summary of what that particular kink in the case was about?
After Dan Markel's murder, the law enforcement ultimately arrest two men who lived in Miami. One was a member of a gang. The other was a close associate. And they arrest a woman who had been the longtime significant other of one of the men. And she also had a relationship with Charlie Adelson, who was convicted last year and a half ago, Donna's son. And law enforcement were pretty sure that the woman, Katie McManoa, would not have independently on her own dime decided to arrange to have someone she never met Dan Markel, murdered. And so they were pretty sure that somewhere in the Adelson family, there was involvement in that murder in terms of setting it up, arranging it, and paying for it. So law enforcement arranged what has been now called the bump, where they had an undercover agent accost Donna on the street. She was going to pick up her grandchildren from school. And the undercover agent said, "I'm talking for my brother who's now in prison, and you need to take care of him." And she reacts in a way that no one who had been accosted on the street by a complete stranger and told you got to pay money, would ever have reacted. She then calls Charlie and she talks to him in code about, "I've gotten this phone call and it was about a TV and we need to talk." That was the bump. And Charlie's explanation for it was that he was being extorted by these two men from Miami. And their view was they had killed his brother-in-law in order to persuade him that he had to pay them. That was his explanation, that these people who didn't know anybody in Tallahassee, didn't really know Charlie, were going to kill somebody that they knew Charlie didn't like, because I think Katie had shared that with them, in order to persuade him to pay them money. So that was the story of the bump, the explanation. I don't know anybody who heard it who thought it was anything other than pretty silly. And even as I say it, it sounds pretty silly. But I think saying you went to Vietnam to just have a vacation, one-way ticket, you weren't getting all your affairs in order, in a frenzy to get out the day of your son was convicted. You were just going there to take a vacation, and it hadn't anything to do with the conviction, and you weren't running to avoid prosecution.
That was an excellent summary, Joe. Great for you.
Very kind. So, Melissa, is there anything you want to add about this hearing or about the trial that you haven't asked me about or that we haven't talked about?
Oh, just that this is a real life saga. As a former police officer myself, I know that truth is stranger than fiction, and this is playing out to be exactly that. You have all these interesting characters and things that you just would not expect in the family that is here, but things you don't know what anybody's capable of. And so this is going to continue to roll out like a thriller as it is. So it will continue to fascinate individuals. I also, it occurred to me, I wanted to ask you, since you have your grade book out, what would you grade Joel? No, I don't want you to answer that. We'll just assign him A's.
Oh, listen, I'm a very kind guest, and I would grade him an A+.
Excellent. Oh, see, I was even going too low. Very good. I agree with that. One other question I have, and then we probably need to let the viewers go and get a little bit of rest because Joel will be back and things will be much better later on today. But how are you thinking about the cameras in the courtroom for all of this? And I realize that we are having wonderful access to all of this case, the hearings and everything that is just not normal. But there is a balancing there. There might be some downsides as well. So what are your thoughts now on if you were to weigh against the benefits and the consequences of these cameras?
I think it's a very important modern ability of the public to see government in action and a trial in action. Under the U.S. Constitution, there is a right to a public trial. Part of that is in the defendant, to protect the defendant from a star chamber arrangement where he doesn't have a chance or she doesn't have a chance to have a fair trial and nobody knows about it. But the other part of it runs to the public. And it is our obligation and our right to be able to look at government action and to assure for ourselves that it's working appropriately and properly. It used to be before cameras that in order to exercise the public right, you either had to rely on journalists to report, so they were an intermediary in terms of your right individually, or you had to go sit in the trial and watch the trial. I think the opportunity for people to watch on TV or on YouTube or, on video is really an important part of being a citizen. And I think it really does inure to a more confidence in how the trials work and how the justice system works and how something that might be reported in a newspaper or somewhere else might not be your take if you actually got to hear the witness or actually heard the testimony and saw the exhibits. So I do think there's some downsides. I mean, there can be a lot of publicity and sometimes that might make it a little harder to keep the trial fair, but I think on balance, it is really an overwhelming plus.
Good. I agree. It's been a positive contribution to transparency. The downsides I've been seeing as I had been reviewing some of the tapes and such is there is a revealing of some private information. For example, you get to hear the names and the birth dates of the children, for instance, and the phone numbers of individuals. So that was just a thought I had recently of some possible downsides to the public nature of this.
Don't you agree? The judge should be able to control that and make sure that sort of private information doesn't come in. And I don't think that would be too hard to do. Sometimes there are mistakes, but I don't think that would be too hard to do. So I see that you said we probably should get off because Joe will go in a little while. And I think that's probably true. Although I do disagree with you that he's going to come in and do it better. I think I heard you say that. I think he will do it as well and more. And he certainly will be more experienced. But in my view, I'd give us both an A.
He'll probably have something to say about all this in a little bit. So thank you for everybody in the chat. Sorry, I couldn't join the chat. Apparently I need to be on Facebook, which I'm not. So it didn't allow me to add myself. And apologies, I didn't introduce myself at the beginning. I just didn't want to talk over because the judge got it started right on time, which is just amazing. Joe, it's been a delight. And I think Mario needs to somehow kick us back off.
Yeah, because otherwise we'll sit here looking, I think, a little odd, statues that are breathing. So, yeah, I do think we need to come off now.
Okay, I think
Facebook says when we say this, he will take us off and play some music as we leave. So, Space Coast.